Don't know if you guys can hear me.
Yep, perfect.
Okay. Good morning to you all, Brona. That was very insightful to me, especially that I'm writing about property too. Except that I'm going to take you to the other side of property, which is all about personal property and chattels. Good morning to you all. I'm sorry to tell you that I'm going to delve into the very complicated details of Lipkin Gorman versus Karpnale Ltd. So as you see, the title, the paper that I'm writing is about the relationship between unjust enrichment and property rights in English law. And I am in this paper, I investigate Lipkin Gorman to basically establish the role that title or ownership has in an unjust enrichment claim. And when I'm referring to ownership or title, I'm referring to the claimant's title or ownership in a potential unjust enrichment liability in English law. So I'm just going to start introducing or talking a bit about the case because I'm not sure if you guys are familiar with it. Lipkin Gorman is the first case where the House of Lords recognized an independent cause of action called an unjust enrichment. Basically, what happened is that at the beginning of the 80s, there was someone called Cass. Cass was a partner in a firm of solicitors. He was authorized to withdraw money from the client's account. Cass was also a compulsive gambler. So Cass used his authority to withdraw money and he basically gambled the money away. He withdrew a huge amount of money, over £300,000. The majority of this money was lost in a club. The club is basically the defendant. The solicitors wanted to sue to basically recover the money. They didn't sue Cass because Cass was insolvent. There was no point. They sued the club instead. They sued the club on the basis of unjust enrichment, where it was first recognized in this case. The club's argument, the case is very complicated and involves a lot of tracing, and I'm not going to speak about all the arguments. And I'm only going to speak about the kind of ownership that the solicitors had, which was supposedly the basis of their unjust enrichment liability. The problem with this case is that when Cass withdrew the money as an authorized partner, title in the money passed to Cass. So title was vested in Cass and Cass alone. So when the solicitors sued the defendant, which is the club, who are retaining the money that Cass lost, they sued them on the basis that they should have title. The club argued that title is vested in Cass, so you basically guys are not owners. So the whole argument revolves around the basis of unjust enrichment liability under this case. The judges, the House of Lords established or believed that the solicitors were owners, but they couldn't explain to us why or how they were owners. It was just morally, intuitively, something about it tell us that they are owners, despite the fact that title passed to Cass. So after Lipkin Gorman, and they were awarded a restitutionary right on the basis of unjust enrichment, they did recover the money as owners without explaining to us in the reasoning how they were owners. And this is the interesting thing about Lipkin Gorman. So after the decision, it has been almost 30 years now, scholars have been struggling to make sense of the decision and to explain where exactly or what is the role of title in unjust enrichment. If title passed to Cass, then how come the solicitors returned or recovered the money or the value of the money as owners? So in the past 30 years, I'm an outsider, have no idea what's going on. I look at the argument and all I see is that there has been this obsession about the passing of title and the non-passing of title, and it's the consequences that it has on establishing unjust enrichment liability. So the discussion is basically about, so what is the basis or what the basis should be in unjust enrichment liability in Lipkin Gorman, or for any fact where your property is in the possession of someone else. without a legal basis, such as theft or loss of and finding, or like a transfer under a fundamental mistake that prevented title from passing. So basically, every scenario where you have title or ownership, supposedly a proprietary interest in a property that is being possessed by someone else. So let's take, for instance, the example of theft, loss and finding. As an owner, can I sue you in unjust enrichment? It's difficult to answer with yes or no under English law and under a comparative jurisdictions as well, but I'm only concerned about the reasons of this complexity in English law. It's always, until now, it's hard to answer the question with yes or no because of that retention of title. So basically, Lipkin Gorman exposed this gap in the law where we basically seem to have been taking the idea or the concept of title for granted. Title did pass to CAS, and yet the House of Lords said that the solicitors were owners of the money. So what does that mean? So what exactly that was the unjust enrichment was responding to in Lipkin Gorman? In the paper, what I try to do is to make sense of Lipkin Gorman after attacking all the discussions in the last 30 years about discussions of some commentators about how Lipkin Gorman should be analyzed. So some would argue that Lipkin Gorman, the basis of the liability in Lipkin Gorman was about the solicitor's ignorance of the misappropriation of the property. And these all were unjust factors, as we know that in English law, unjust enrichment liability has three elements: an enrichment by the defendant at the expense of the claimant, and with an unjust factor. So the equivalent to that in civilian systems is without a legal basis. So scholars were saying that it's probably the solicitor's ignorant that should be the basis of the liability, and some argue that no, it's not. Ignorance doesn't make any sense. It's not logical. It's actually the misuse of the partnership assets that should be the basis of unjust enrichment liability. And these unjust factors are basically continue to be proposed by scholars in the last 30 years. And in this paper, what I try to say is that the unjust factor, it does not solve the problem. If anything, it makes it worse, because it will still bring us to question number one: how come the solicitors were owners of the money? How can we deal with the fact that unjust enrichment responded to a situation where title was vested in basically the thief, which was CAS, and yet the solicitors were treated as owners. So it's like saying that CAS was an owner, but the solicitors were the true owners. So what does that mean in English law? And what is the extent for that concept? And is it even possible at all? So in this paper, I argue that probably the closest explanation for that position that was taken in Lipkin Gorman is the idea of relativity of title. Is basically very against what Brona said about the exclusion in probably ownership of land. What happened in Lipkin, I argue, is that the solicitors, the money belonged to the solicitors. I don't know how to basically make sense of the idea of belonging of the property to the solicitors, but I know that it may be investigated through the concept of relativity of title, where more than one person have weaker or stronger title in the same property. That's one, and two. Then the gap that Lipkin Gorman basically exposed is that we have been taking the term and the concept title for granted. We talk about title sometimes in a very loose sense as a synonym to ownership, but then in Lipkin Gorman, this is not the case at all. The case was that title basically meant nothing. Title that was vested in CAS meant nothing, because the solicitors still managed to recover. So that interaction between unjust enrichment as a very moral principle and the idea of belonging, which I am investigating through the relativity of title, that is basically what I'm trying to do now. Is that there is something in the background. We don't know. There is a different kind of ownership, way broader than the orthodox sense of title, which was vested in Cass, that unjust enrichment defends. I think that's all. I am still under investigation, and I am still trying to identify what does it mean that something belongs to you, despite that title passed to someone else. What does title mean in that sense, and what does it mean that something belonged to you again, and how would unjust enrichment in English law respond to that kind or that form of ownership? Thank you.